I've been teaching here since about 1985, and teaching already at that point was Michael Stout, our next speaker. I first met Michael when he was handling a capital case resulting from a prison riot in New Mexico. I cannot imagine a worse case than somebody who's already in prison being involved in an out-of-control situation, killing other people. And yet, that's how I met Michael involved then. He was a public defender then. He left private practice, became a private criminal defense lawyer first in Roswell, New Mexico, now in Las Cruces, New Mexico. He has taught hundreds and thousands of people here in Kentucky and all over this country on how to listen, how to get information, how to have conversations with jurors. He's a terrific teacher and a terrific lawyer, and writes wonderful Christmas letters. Michael Stout.
Thank you. Good afternoon. I hope you're having a wonderful time here. A note has just arrived from the dean's office, and it's from your office. And the note says, Judge Jones, who has your case, which is scheduled about a month from now, has found a place on her trial docket and is able to move the case up. And so she would like you to come over and pick a jury tomorrow morning. So I have a couple of questions about that. How would you feel if you got that note? Good? Bad? I see a lot of, oh shit, that kind of thing. Well, let me ask another question. Do you think it even matters? Do you think jury selection even matters? Okay. Well, I think that's probably right. Here, we have here a jury full of cats about to decide what happens to the dog. And for some reason, the lawyer says to the dog, this doesn't look good. It doesn't look good. Why is it? Because we have cats. Can't cats be as good at jurors as, cops or dogs or anybody else? No, because we make this assumption that who's on that jury does make a difference, right? It does make a difference. Now, there are some cases in the world where it makes no difference at all. There are some cases that are so strong for the prosecution or so strong for the defendant that whoever's on that jury is going to have the same result. But I'd say that's probably about 3 cases in the universe. And the other 99% of cases are those cases where we know it makes a difference, that one juror makes a difference, or 2 jurors. And we've heard of stories where a juror swung the jury one direction or another, right? We know it matters. How important is it? I was married by a judge. I should have asked for a jury. I think Groucho at least thought it was important. But so let's think about that situation I just gave you. You get the note. You got to run back home. You have to leave your newfound best friends, and you have to go back and select a jury. What is it that you are afraid of? What is you concerned about? You're going, okay, what's the first thing I'm going to do? Oh my God, let's see, I've got to do this. Okay, who am I going to talk to? What am I going to ask? Gosh, do I need to file a motion? So what is it you're going to do, and what are you scared of? I'm sure I would be scared in that situation. So let me ask you, what are your fears about that situation? Yes.
They're gonna have a bias already if my client doesn't testify.
Say it louder.
They're gonna have a bias if my client doesn't testify. I'm not gonna pass that.
You're worried about your client not testifying, and the jury's going to be biased against that. Okay? What else? Yes.
What if I misunderstand someone in communication and pick the wrong person for the jury?
I picked the wrong person. We just talked about how important it is to have the right person. If we pick the wrong person, they're coming down on me, basically. What if somebody misunderstands? Back in the back.
I can't get them talking, it's just like crickets.
It's just like what?
It's just silence and I'm asking questions and nobody will speak up or volunteer.
Can't get any information. Can't get any information. They won't. It's like they, they didn't want to be here today, maybe, or something, right? So they don't give you any information, right? What else? That's excellent. Yes, ma'am.
That the one question that you don't ask is going to be what makes the difference? Like that you forget to ask about something important.
Forget to ask about something important, and you wish you'd have found out that information. It would have been revealing. Good, excellent. What else? What other concerns do we have? Yes. I'm sorry, I'm not getting the names. Would you give me your name, please?
Shayla,
Shade, okay.
well, in Georgia, a lot of times the judge will conduct a lot of the general questions. So, or he'll feed you along, oh, you've asked it already, Ms. Galloway, or keep it moving, she's already answered that. So it's this feeling of not feeling like you're doing a thorough job.
You're not being thorough, and the judge is a jerk, right? Okay. Yeah, okay, good. How many of you have that problem with judges? Anybody ever seen a jerk judge? No. Where's Joe Johnson? When do we meet? Okay.
Well, on that line, being held in contempt by the judge for trying to develop a rapport with the jury and not asking that typical, is that going to bias you against my client question?
Okay. Have you been held in contempt?
I've been threatened.
Okay, all right. Well, I got you beat by one then. All right. See State v. Stout. It's a New Mexico side of Chase. By the way, I was acquitted. Okay, anyway, what else? What other concerns do you have? What other concerns are there? Yes, ma'am. What's your name?
Liz.
Liz, and you are Jason, okay.
Like when to use your peremptory challenges and like to finish and use all of them, but use them like appropriately.
Worried about, again, who to pick, right? How to use your peremptory challenges, okay? Yes, your name?
Alec,
Alec?
no matter how big the pool is, it doesn't work.
What does that mean?
That means you have 12 and an alternative and 20 more, and you just don't feel them and they don't feel you. So what do?
You don't have a relationship with them, you mean? Okay. Yes, you're Dean. Jen. Jen, I'm sorry.
Then I'm gonna throw up on the podium before I even start talking.
I'm gonna throw up on the podium, that's a common one. Okay, good. How many of you have actually thrown up on the podium? All right, no, but you're feeling it, right? Okay, good, very good. Yes, sir, Justin.
You get a bad pool and they've already been rejected by a bunch of prior trials.
Okay, that's a systemic thing where you have jurors who were the rejects from the bad case before, right? And they were so bad they were rejected by your colleagues, and now you have to have them. Is that the way you feel about it? Okay, good. Who else has a concern about what's going to happen? Yes, what's your name, please?
Tina,
Tina?
that they're lying and you're not going to be able to spot the liar and he's going to get on your jury.
Where are you from?
Colorado.
Colorado? Jurors lie in Colorado?
It's really conservative. We're in El Paso County. And
Wait a minute. Okay, Colorado, that's the one state I've ever heard of that had a lying juror. Anybody else here from Colorado, or anybody else seen a lying juror before? Oh, wait a minute, I can't believe this. All right, yeah, no, the jurors lie all the time, right? We're afraid we're not getting good information. El Paso, that's Colorado Springs?
yeah.
Okay. Who else had that? Yes.
There are going to be jurors that just want to argue.
Argue with you, okay? Give me an example of that.
Like a DUI case where you're going to get a juror who's just going to keep saying that no matter what, if there's any amount of alcohol, they were driving and that's the end of it.
Okay, you know what the definition of peremptory challenge is?
We got to wait until the end to...
Okay, no, but if they're going to argue with you, sure. We don't want to get into debates, that's right. Okay, who else has something they want to raise? Yes, what's your name?
Tom,
Tom?
that you're gonna get that your pool's gonna consist of people that their line of thinking is gonna be, well, he may not be guilty of what he's charged with, but he must have been doing something wrong, so we're gonna find him guilty.
Okay, I was about to say that was a good juror in my view, but until you put that last part in. Yeah, okay. All right, well, these are all legitimate concerns, every one of them. And we're going to try to address some of them in the time we have, to the extent we can. One thing I will say is that, like, for instance, was it Jen that would tell us about the nerves? And that's a common, I mean, after doing this for 150 years or however long it's been, I still, when I go into a courtroom, I'm antsy, I'm anxious, I'm nervous. And I think if you're not, you're probably not in the right profession. So that's common. But one thing that I try to do when I'm in that situation, I'm going, oh my God, Jesus, oh shoot, I sure hope I don't screw this up or whatever, is I try to say, self, this is not about you. You know, this is not about you. This is not about whether you appear to be this brilliant lawyer or well-educated, intelligent, whatever. This is not about me. Because this is about, as you just heard, it's about a client, for one thing. And it's about jurors. The client, what do you think the client has to be there? You know? And the jurors, they didn't ask to come down and tell you their personal shit, right? So they didn't want to do this either. So one thing that can help a little bit is to shift that focus away from you and onto the people that matter in the process. All right, so we'll talk about how we deal with some of this. In a perfect world, we would have an optimal conditions, meaning we'd have either individual voir dire, we'd have a very small group, we'd have all the time in the world we needed, we'd have very comfortable setting, so forth and so on. And some places are pretty good at this, and some places are terrible. And I bet you some of you folks know some places that are terrible. And this is what we'd have. And we get a whole bunch of pretrial information too, from questionnaires or from investigation or from other sources. And we'd always have these open questions, have these good conversations for as long as we wanted. That'd be in a perfect world. Our goals, regardless of the perfection of it, is first of all to learn from the jurors. This is the very optimal, first, high priority, top priority goal, okay, is to learn. Your goal, if you ever ask tomorrow, what's your purpose here? To learn about this person. There are other purposes of voir dire, but the first is to learn. And then we want to teach also. We want to teach them some things because we want them to teach themselves. We want to have a conversation that's educational about some of the issues in our case. And of course, we want to have a decent rapport with the jurors, meaning we want to have a relationship that is respectful. This isn't a love fest thing. This is a professionalism issue in terms of having a relationship that's respectful with the jurors. So, how do we get this? Well, first thing, we're going to talk to some of those judges. If we're going to pursue perfection, here's some suggestions. What I do is I've talked to some groups of judges at sometimes, and I've also gone to some individual judges. I had a federal judge who allowed me to sit in a case of hers and then write a letter with my thoughts about how things might be improved and so forth. And she was very good to let me do that. And I've talked to just individual judges about how to improve this process that we have because it's real spotty. And this is one thing that I preach to judges is forget fairness. Stop talking about fairness. I don't want a fair jury, okay? I don't want fair jurors. I want honest people. That's what I want. And if we start telling people that they should be fair, then what are they going to do? They're going to tell us they can be fair, right? It's like going to church and saying, well, you said. Well, of course not. Not that I know anything about church, but so we don't want judges to stress fairness first. We don't want them to stress impartiality. We want them to stress, you just be honest with us. We'll make the decisions about you later. Set the tone for openness. The judge needs to set a tone in his or her questions for openness. Improve the physical setting. You notice I move these chairs to move these obstacles. I do that in courtrooms too. Move chairs, move briefcases, get the distance closer. There's all kinds of things that judges can do that they think are going to hurt them somehow, but we're no skin off their nose. Improve that setting. Thin the herd, meaning get rid of jurors you know you're not going to be using anyway. And so have the smallest group you can, because communication's better in smaller groups. Supplemental questionnaire. We're not going to have time, as much time as I would like, to talk about this point. But this is an incredibly important point. Supplemental questionnaires are, I've had one in every jury trial I've had in the last 20 years. I take a questionnaire to the opposing counsel, I submit it to them, they say, go to hell, and we see on what we agree or disagree, take it to the judge, and we end up with something. We have some kind of questionnaire, but you get golden nuggets in there, because people will say things in questionnaires they won't tell you to your face. And they'll say things in there that about private things. So we can talk more about questionnaires and how to get them and so forth, but please become committed to trying to get questionnaires, at least if it's just a one-page, three-question questionnaire, whatever it is. All right, I tell the judges, judge, reduce your role, and don't rehabilitate people. Don't rehabilitate jurors. And require open-ended questions. I say require? Yes, require open-ended questions so that we can all have, kind of like direct examination, we can all get the information. Okay, does this also always work? No, it's not. And is it always going to be what you want it to be? No. Are we going to get jurors who, we're not making this choice between the perfect juror and nobody. We're making the choice between Jones and Smith, one of which is horrible and the other is miserable, right? So that's our choice. And so we have to get the best information we can to find out, to make our distinctions between these jurors. Okay, now then, let's talk simply about, and I know that we've talked a lot about communication and emotions, empathy, and so forth, all of which is appropriate. And perhaps it goes without saying that words are a very, very small part of communication. Language. But we lawyers, what did we do in law school? What do we do all the time? We're always evaluating language. We look at the statute. We look at the rule. We look at the case law to see what it means. We're looking at the language to make distinctions. So we're always dealing with language. And we're going to deal with language here today. But just keep in mind that communication has to do with numerous things, a list of things, as long as you can count, that are other than words. We have the temperature of this room, okay, the number of people in the room, the pace, the volume, the inflection, the tone, you name it, the body language, eye contact. There's a million things that go into communication that don't have a thing to do with the words. But having said that, we're going to talk about some words, okay? So, we're going to talk about the core. This is what I want you to do for tomorrow and for your next trial, is the core of every question. This is what your question should be. It should be very short. Your question should be very, very short. The shortest question you can ask. It should be clear, okay? And it should be open-ended. Now, what does open-ended mean? Open-ended means it can't possibly be answered with a yes or a no. It cannot be answered with a yes or a no. That means it's open-ended, okay? And that's what we want every question to be. So if we just take one question and make it like this, short, clear, and open-ended, then we'll be okay. In terms of short questions, sometimes you have to work at it a little bit. Not that the story need be long, but it'll take a while to make it short. Sometimes to be concise, we have to think about how it is we're going to shorten that down. So use a little time to think about that question to make it short. Okay. There's really only 3 words you need for these questions tomorrow. Or forever, for that matter. And I'm not suggesting you only need 3 words all the time, but there's only 3 words you need. And that is, what do you think they are? Anybody got a guess what the 3 words are? Daryl, I think they left. What? I'm I'm sorry? I heard one of them. Why? There's one. Okay. What about what? Okay, there's a word you can use. If you start your question with that, you're going to be okay. Okay? How? There you go. Beat me to it. And of course, as we already said, why? You start your questions with one of those three words. Now, this is very mechanical, right? This is very formulaic. And obviously, again, it doesn't go into the body language and all the other factors of communication. But if you'll start with this language, you're going to end up in a better place, I think. So let me read to you a sample voir dire. I forget. I think this is in Carlsbad, New Mexico. It says, Mr. Juror, I understand you read some things about the case. Could you put aside that information and decide this case? What's your answer to that? Okay, I hope so. Would you obey the order of the judge? No, I would not. In fact, I hate that judge. This case involves firearms. Is there anyone so opposed to guns that would affect your judgment? Can you set aside your feelings and decide the case fairly? Is anyone opposed to guns so that? That's three questions, right? And the answer is no response, right? Just what you'd expect. This case involves self-defense. Does anybody have any problem with that? Right. This juror's getting better and better. Do you believe in the doctrine of self-defense? No response. Concerning the burden of proof, does anyone have any problem with that? No response. Okay. Have anybody seen these questions before?
Yep, the prosecutor.
Yeah. Right. Okay, so these are bad questions. Does everybody understand that part? Okay, this was not a good example. This is a bad example. Okay, so why are they bad? Why are these questions bad?
Jurors aren't talking. You're not getting any information from them.
Right. We're not getting any information from the jurors. They're not talking. We're getting some kind of spiel from the lawyer. Okay, so let me ask you to do something real quickly. Somebody tell me a subject, just a bland, nothing loaded, nothing exciting, just a bland subject.
Macon, Georgia.
I'm sorry? A bland, okay, Macon, Georgia. That's fair enough. Okay. Everybody pair up with somebody. Just pair up with somebody. Quickly now, we don't have a lot of time. Just pick the person next to you, pair up, and one of you, everybody pair up. Okay, listen up. Here's the rules. One of you is number one. Pick the number one. One of you is number two. Okay, number one, you are the questioner. Faculty, you get to play too. It's all right. Number one, you're the questioner. Number two, you're going to be the answerer. Here are the rules. Answer truthfully, but give as little information as you can. Okay? You give as little information as you possibly can. Let's do a little example here. Here, Justin, is it?
Yes.
Okay, you be number one, I'll be number two. Go ahead.
Juror, do you
No,
have,
I'm just a person. Go ahead. The subject is Macon, Georgia. Go ahead.
do you have any feelings about Macon, Georgia?
Yes.
You couldn't hear the question, Mike.
The question was, do you have any feelings about Macon, Georgia? And the answer was yes.
What are those feelings?
The feelings are that it's a southern town, about 100,000 people, pretty good city.
Why do you feel it's a pretty good city?
Because it's done some good things.
What kind of good things has Macon, Georgia done?
It sponsors the National Criminal Defense College.
What are your feelings about the National Criminal Defense College?
I love the college. Okay, these are good, okay. Justin did a very good job, except for the first fucking question, right? He didn't follow the rules, right? Follow the rules, okay? All right, okay, ready? I'm going to give you like 60 seconds. Ready? Ones and twos. Ready, go.